SRM Institute of Science and Technology. Learn, leap, and lead.
Good morning, everyone. Welcome to the Future Career Conversations series, jointly organized by the SRM Institute of Science and Technology and The Hindu. Today, we will be discussing the topic Constitution under the Microscope, Federalism, Free Speech, and the Indian Republic. I'm Radhika Santanam, your moderator for today. We will begin with a special address by Professor A. Vinay Kumar and Dr. Sri Sada. Professor A. Vinay Kumar serves as the Pro Vice Chancellor for the Faculty of Science and Humanities, School of Law, and Faculty of Management at SRM Institute of Science and Technology, Kadingolathur. Before joining SRM IST, he was a distinguished professor of finance at IIM Lucknow and also held the position of director at NMIMS University, Bangalore. Under his leadership, NMIMS consistently ranked among India Today's top 20 institute for two consecutive years. Dr. Sri Sada is a passionate legal educator with over 2 decades of experience in teaching, research, academic leadership, and community based legal outreach. She's an authority in international trade law, intellectual property rights, cyber law, and international tax law. Prior to joining SRM IST, she served as the Dean Examinations of the Damodaran Sanjeevaya National Law University, Vishakhapatnam. She has authored books in sports law, IPR, and privacy law, and has also published articles in prestigious national and international journals. I will now open the floor to their addresses.
No. Can I go?
Yes, sir, please start.
Yes. Welcome everybody who is part of the webinar, specifically Suhrit Parthasarathi, who's our guest, Dr. Akila, and Dr. Sudha and Dr. Sumana, who are part of the panel. I think it's a very relevant discussion that we will have today about federalism and how we should basically sort of delineate powers between national government and state governments so that there is a direct connect between governance and people. And I think today's discussion is going to be quite interesting because some of the best speakers are lined up for the session. And I think we'll also throw some light on the other related aspects in the webinar. I'm looking forward to contributing to the webinar. Thank you. Dr. Sumana, Dr. Sri Sudha, I think you can also say some initial statements.
Thank you, sir. Esteemed Pro Vice Chancellor, Professor A. Vinay Kumar, sir, and the speakers of this webinar, Mr. Suhrit Parthasarathi, Akila, and my dear colleague, Dr. Sumana Vedant, people from Hindu group, as well as audience. A very good morning to one and all. The topic for this webinar is very, very relevant as well as timely. Today, 24/7, we are speaking. We could be in a position to read the content from diversified platforms, especially the influence of social media is immense in the minds of the people. On the backside of the coin, to get this freedom, 77 years of sacrifice is there behind that. But unfortunately, if a person expresses his opinion vocally, immediately, in the name of takedown of the content, internet shutdown, as well as filing criminal cases before various cyber police stations is going on. That is the reason why we have selected the topic in a way that constitution is under microscope. There is a balance between center as well as the state. This freedom of speech and expression is a very important fundamental rights guaranteed under Article 19(1)(a) of Indian Constitution. But when it comes to conferment of this right to the citizens of India, there are three important players are there. The first one is that we are getting access of internet that is under the control of Government of India, central government, as well as the state governments are responsible for the purpose of maintenance of law and order, public order, as well as decency and decorum of the society. There is a strong connection between center and state for the purpose of protecting this important right, freedom of speech and expression. But unfortunately, because of lack of coordination between both the actors, sometimes this freedom is subjected to curtailment. So that is the reason why if a person approaches the court of law, every time the courts are giving utmost important to freedom of speech and expression rather than the restrictions which are mentioned under Article 19(2). From SRM School of Law, we are offering UG as well as PG courses, but this Master of Public Policy course is a very, very important course which can shape the various policies which are aiming at promotion of this free speech through digital medium. Being a future policy implementers, there is a role for the purpose of shaping this law to ensure, protect, as well as guarantee in an effective, efficient way, as well as based on the evidence only, there should be a factor to this free speech in the virtual world. Thank you for a wonderful opportunity. I wish the panel members will throw a light into this topic so that a balanced approach we can arrive for the purpose of protecting this freedom of speech and expression. Thank you.
Thank you so much for giving us the context for this discussion. I would now like to introduce our panelists for the day. Dr. Sumana Vedant is an associate professor at the SRM School of Law, SRM Institute of Science and Technology. Her profile is shaped by active engagement in moot court debates and other co-curricular activities alongside professional experience in court practice, corporate law, and academia. Her areas of expertise span Indian constitutional law, human rights, intellectual property rights, and international law. Welcome, Dr. Vedant. Then we have Suhrit Parthasarathy, who practices as an advocate at the Madras High Court, Chennai. He holds degrees in law from NUJS Kolkata and journalism from Columbia University, New York. He has contributed to several books, including Incomplete Justice, the Supreme Court at 75, The Appointment of Judges to the Supreme Court of India, and he has co-authored, along with former Attorney General K.K. Venugopal, M.K. Nambiar, a constitutional visionary. He's a regular op-ed contributor to many Indian newspapers, including The Hindu. Thank you for joining us, Suhrit. Lastly, we have Akhila Aris, an advocate practicing before the Madras High Court and trial courts in Chennai. She's an independent researcher as well and works on issues of human rights law. Akhila graduated from the National Law School of India University and has master's degrees in law from the University of Oxford and NYU School of Law. Before moving to litigation, she worked as faculty member of the National Judicial Academy, Bhopal, National Law School of India University, Bangalore, and National Law University, Delhi. Thank you for joining us, Akhila. So let us start this discussion by talking about federalism. In recent times, we have seen center-state relations that have been under strain over several issues, both political and financial, including rationalization of GST, the Finance Commission's recommended share, and interventions challenging regional autonomy, such as the abrogation of Article 370. Some opposition states have been particularly vocal about some of these developments. Recently, we had Tamil Nadu Chief Minister M.K. Stalin say that the constitution should be amended to make it more federal in nature. Let's start with you, Suhrit. Do you agree with with his suggestion that the constitution needs to be made more federal in nature? And if yes, in what ways can we make it more federal?
Thanks, Radhika. Well, I think it's useful to begin by recognizing a basic constitutional truth, which is that India was never designed to be a classical federation, right? The Constitution deliberately avoids the word federation. It speaks instead of a union of states. But having said that, when you look at the text of the Constitution, its framing, and the distribution of powers between the various wings of government, what you will find out, and the sort of truth that we arrive at, is that there is a division of power between the union on the one hand and the states on the other. Now, of course, there is a general concern, and this is not something that is recent. This is something that has happened over the course of our constitutional history over the last 40, 50 years, where the union has expanded its influence through the concurrent list, often encroaching on traditional state subjects. And as you pointed out, fiscal power has come to become heavily centralized. Taxation, borrowing, and even welfare design are largely controlled from Delhi. And you also have the other mechanisms like governors and other centrally sponsored schemes, which have increasingly become instruments of political or administrative control. So I think we don't need to necessarily look at amending the constitution in order to make it more federal. But what we should certainly look to do is to ensure that its basic essence is maintained, in that when we interpret the constitution, we don't interpret it with a unitary tilt, but with a federal tilt. And I think there are at least three meaningful ways in which this could be achieved. One, obviously, is to restore fiscal federalism. You've got to give the states a greater say in GST design and revenue stability. Revisit centrally sponsored schemes. And because ultimately you cannot have political federalism without financial federalism. The second thing to focus on is obviously a rebalancing of legislative power. Perhaps you'll have to tighten the scope of the concurrent list. You'll have to strengthen institutions like the Interstate Council. Maybe there are certain subjects in which states ought to enjoy greater autonomy, things such as higher education and so forth, where in terms of setting standards for the state, and this has been obviously a bone of contention for Tamil Nadu as a state. And thirdly, and I think most importantly, you've got to reform the role of the governors and the constitutional processes. And I think here we've not been sort of particularly helped in terms of how the courts have also stepped in to ensure that federalism, at least as guaranteed by the Constitution, is respected. In the interest of time, I can't go into every little detail here, but we've had substantial debate over the Supreme Court's intervention with respect to the governor's powers. There was, of course, a landmark judgment delivered by one bench of the Supreme Court, where several constraints were sought to be placed on the powers of the governors. Of course, there is an argument to be made, and some make that argument, that perhaps in certain areas that judgment might have gone beyond what the Constitution itself might say. But ultimately, the judgment at least tried to bring about some procedure to this process and ensure that certain timelines are respected, because you cannot have a governor sitting on a bill that is lawfully passed by a state assembly for months on end. And you've had the subsequent presidential reference, which has sought to water down a lot of what the earlier judgment has held. So we don't know how this will ultimately play out. It might have to play out in a subsequent case. But I think these are at least three ways in which the Constitution can be made more federal without, in fact, amending the Constitution.
Right. Akhila, do you think that there are any other suggestions that you could provide?
We can't hear you, Akhila. I think you're...
Yeah. Am I audible now?
Yes.
Yeah. So federalism is part of the basic structure. Any reform, whether it's through interpretation, whether it's through constitutional amendment, should be in furtherance of it and not detract from it. So in terms of the Chief Minister's call for constitutional amendments to strengthen federalism, well, one, I don't think it's probable in the current political scenario. I don't think it's even possible to push for an amendment. But I think it's an important moment which signifies that, it's important to rally behind these issues, right? And I think this process is far more important than should we, prioritize and how do we ensure that there's, fiscal autonomy, etc. I think it's an opportunity to, for states to speak together, to understand priorities, learn from each other's experiences, drive a consensus, build momentum, and ask for certain reforms. Because this is a concern that's been articulated by most states, especially where the governments in power are those that are opposition political parties, right? That stand against, are different from the central government. So there is a consistent apprehension that there is control and domination rather than cooperative federalism at play, which signals some kind of constitutional crisis. So we definitely need to work on it. But I don't see constitutional amendments being problematic because, well, constitution is a living document. There have been 100 plus documents, plus amendments over the past many years because it needs to stay relevant. It needs to address the exigencies of the day. So insofar as that is concerned, the latest Korean Joseph report, which has been tabled, speaks to constitutional amendments in order to entrench and to sort of strengthen federalism. I see some merit in thinking about it, but I think it should serve as a point of advocacy and consensus building between all states to address and reset the imbalance of power between the union and the states.
Right. Thank you. So, Dr. Sumana Vedant, Akhila says that it is probably not possible at this point of time, this suggestion. It may not happen. What do you think?
According to me, the Constitution has been very subtle when it comes to the role of governors. Basically, it's not too expressive, nor does it speak very, very seriously, saying that it has to be like this. But then it has given some role to the governors. So now probably the
Sorry, you're talking about the role of governors?
Yes.
Okay.
So
okay.
when it comes to what happens is, as Akhila was mentioning, normally the governor is from, they are appointed from the center. So there is a kind of there's a kind of friction that happens between the state government, which is led by the chief minister, and the governor's perspectives. So I feel there is some kind of, when the Constitution was, it was made, probably this is one of the ways of checks and balances that we probably need to have. So that was the whole reason, because see, now when I say something, if it is simply accepted by everybody and just gone with that, then even if there are flaws, probably we would not look into it. So it was through that idea that, this whole aspect is there. But then now what is happening is, it is like a thorough friction. Probably all it takes is to sit across and discuss the matter and come to a conclusion. So that is where the ultimate thing lies. So it is not about amending the Constitution, or even so, if you want to amend the Constitution today in that perspective, maybe you make the role of governor more explicit. Say what exactly is that he is supposed to, or I agree that sometimes they sit on the bills and they don't pass and all that. Yes, they are, that's not right. That's not right. Either you reject or you accept. That's the whole thing. But now what is happening is, it is like more of a ego clash rather than anything else. So according to me, it is one of the ways of checks and balances. because the governor's role is to see if something is not perennially right, then he has to say that these things need to be changed, or these things need to be amended. I mean, you have to go with some change. So that is what is his role. So that is my way of looking at it.
Right. So, Surit, I'm going to pose this question to you. She speaks about the role of the governor in ensuring cooperative federalism. Now, of course, as all of you have mentioned, there's been a lot of friction between center and opposition-led states when it comes to governors. And recently, we saw that the governors of at least 3 states, Tamil Nadu, Kerala, and Karnataka, refused to read the full cabinet-approved address in the assembly. But Dr. Sumna Vedant says there needs to be a clear, there needs to be a clear idea of what the governor does. Isn't this something that is already laid out? And how do you think the balance between the center and states can be maintained in the case of governors? I mean, isn't their role already clear? Surit?
Yeah. So, for one, I think that the governor is a product of a colonial vestige, right? I mean, it flows from pre-independence days, and governors were perhaps necessary under the scheme of the Government of India Act 1935, when you didn't have a constitutional court, really. I mean, you did have courts, constitutional courts of a certain kind, but you didn't have this sort of check and balance flowing from an independent judiciary in the manner in which it is envisaged under the Constitution of India 1950. So I'm not sure we necessarily need a check or a balance coming from the governor, because if the state, and because ultimately the governor, even under the constitutional scheme, is bound by the advice of the Council of Ministers. So if the Council of Ministers, in their wisdom, have suggested or have placed a bill for the governor's consideration, then obviously he can, return it once for reconsideration. But if it goes back, he's duty bound to sign it. I don't think there is any exercise of discretion that is available to him. And I think the case law on this is also fairly clear, although it was sought to be argued during the recent disputes before the Supreme Court, that the governor enjoys an element of discretion. So, but coming to this issue of, the governor's address, look, ultimately, it's a constitutional requirement under Article 176. But again, it represents the government's policy statement to the legislature. I would think that the governor here cannot possibly be expressing his personal opinions. It is the elected Council of Ministers' voice that is to be spoken through the governor before the assembly, and that is how the Constitution envisages the role of the governor. It is ultimately today a ceremonial post, and in the larger scheme of things, if we have a fully functioning sort of institutional system of judicial checks and balances, there really should not be any necessity for someone who is the appointee of the union government to sit on judgment over the state's decisions, because the state is autonomous in its own realm. It is sovereign insofar as the subjects in list 2 are concerned, for example.
Right. Akhila, so how would you respond to that? Do you think, first of all, given that this governor's address, is it necessary at all? And secondly, do you think that there should be a way in which the governor should be appointed? Because Suhrit just mentioned that, he's appointed by the union government. I'm sorry, he's appointed by the president. But there have been suggestions in the past of, the CM having a say in appointments, or having a committee comprising the prime minister, the home minister, the speaker of the Lok Sabha, and also the chief minister of the state concerned. So if we are speaking about the governor, do you think the problem lies in the way the governor is appointed? What are your thoughts?
Regarding the address by the governor to the legislature, I think Suhrit has made that point, that it flows from the Constitution. We have a mandatory provision which says that, certain commencement addresses would be made by the governor. And Constitutional Convention has consistently told us that the governor is to read out basically a pre-approved address, right? Which only speaks as to the government policies, the legislature's priorities, and their goals for the session, etc. It is not a space for personal address, not to voice their personal opinions. Uh, so insofar as that part is ceremonial, that again, this is not the first time that it's happened. Governors sometimes do step away from the advice of the Council of Ministers. They have refused to read out as is, have walked out of the meeting, etc. That is improper. It's inappropriate. Speaking from the perspective of the Constitution, does it serve a function? Well, it is more ceremonial than anything else, and I think that stems from the fact that the Constitution itself says that the legislature includes the governor. So it is to mark the beginning of a particular session that they are called in to address the legislature. Uh, the problem is the kind of conflict that symbolizes, and I think it drives home that not everything is well, right? It disrupts the session. And we may have to take a relook at, should we retain this? Does it have any purpose today or not? But as it stands, because it's already mentioned in the Constitution, the governor has to make the address. With regard to the appointment of the governors, I do see some merit in trying to reform the appointment process because we've seen over the past many decades the friction that has come through. And we've seen that governance is disrupted because of this friction. Important bills are not passed. So much other sort of disruption happens. And, we've seen the language that's used in constitutional law is that the governor is supposed to be a link or a bridge between the union and the states, where where the governor looks at themselves as a political appointee and acts as a roadblock. And what ends up happening is that a democratically elected government is not able to fulfill its mandate, then it seriously is a problem. In that sense, there have been several proposals in the past about how this appointment process should be modified, should be reformed. And I think the latest report speaks to how there should be a short list of candidates that have been vetted by the Council of Ministers, and that a governor should be chosen from amongst them. So I think whether or not this is the ultimate proposal that is best to appoint governors, we do need to have a conversation about it, because opposition-led states are facing a lot of problems, which leads to expensive, unnecessary litigation where every, point of executive action, legislative measure, then goes to the Supreme Court for adjudication, because we are not able to do it in the state. So, yeah.
Right. Surya, just coming back to you, one last comment on the governor's address. There have also been instances where the governor has had to read out criticism of his own actions in the past. So would you say that then the governor is right in having a problem with reading out?
Yeah, I mean, I think that might be unfortunate, but that shouldn't speak to the nature of the constitutional requirement in itself, which is that ultimately under Article 176, he has to read out an address, and it has to be an address that is prepared by the Council of Ministers, which is why I think, this is possibly something that we can look to ultimately do away with, because why should the governor have to address the legislative assembly at all? I think it should be simply open to the chief minister or any other minister of the state cabinet's choosing, who can address the house. And because you don't have instances of, I think, at least not in recent times, or not to my knowledge, of the president having necessarily deviated from the presidential address. Of course, there will be instances where presidents might send back comments, might give suggestions. If it's constructive, then yes, it works well. Which is why I think ultimately it all comes back to what Dr. Ambedkar said about constitutional morality in India, in that it comes to the manner in which it is practiced, and the people who are practicing these the text and the institutions that the Constitution has given us. It'll depend largely on whether or not we keep those larger values in mind.
Right.
Yeah.
So, moving on to the question of free speech, which Dr. Shrisuda had emphasized on during her opening address. We have seen, especially in the recent past, lots of instances of hate speech in India, and especially by political leaders. A recent study by the research group India Hate Lab found a 74.4% surge in hate speech against minorities by politicians in 2024. Now, the Election Commission seems to remain a silent spectator to many of these instances, and the opposition has not been able to effectively challenge any of these in court. So, how can constitutional safeguards be enforced effectively when political power shields perpetrators of hate speech? Dr. Sumana, if you could respond to that.
Well, 19(1)(a) probably is one of those rights which everybody have taken for granted these days. Probably that is what I feel, because when we read Article 19(1)(a), we tend to overlook 19(2). What are the things that when you're not supposed to, or what you're not supposed to. This is what is happening. I have the right to speak freely, that's fine. But then I also have access to media, that's fine. And I have access to social media. But then what is it that I'm speaking? What is it that I'm speaking, and why am I speaking about these things? Is it to spread some hatred among people? Why is that? Why spread hatred as such? So this is not, people may be angry. I don't disagree with that. See, people may be angry for various reasons, for the policies of the government, or whatever the government is doing and whatever the government is not doing, all these things. Or they are unhappy with whatever a section of people are getting and what other section are not getting. That's fine. But then there's a way to deal with it. But everybody tends to these days take it for granted and speak whatever they want.
But Dr. Sumana, this is not about people spreading hate speech. This is about politicians themselves.
Well,
so
exactly. Politicians are doing this in view of the vote bank. See, now their way of looking at it is the vote bank. So they are trying to grab a section of people for themselves. So that is where they are doing it. But the problem is that we don't have a mechanism to stop the politicians as such to, stop doing this. Where is the mechanism?
Well, so, the mechanism, the Election Commission is supposed to step in, but has not been able to.
But they haven't. They haven't. So probably we need to have some kind of policy in place where we need to restrict them while they are campaigning or whatever they are speaking on in public platforms. So first we have to stop that. Only then people will realize, okay, fine. So if you are speaking as a political leader, you have thousands and thousands of followers, lakhs of followers. So they will be always influenced by you, right? So if you are doing it, they think it is okay for them also to do that. So we have totally, we have gone so way ahead of, looking at all these things. Sorry.
So, you can go on. I was saying, once you finish, I have a point. I just need that.
So that is what I feel. See, now you, somewhere you need to make them realize what is, how do you use this right? Or how do you, actually exercise this right, basically.
So I thought the disclaimer is I'm not a law expert. I'm a finance professor, but I have some understanding what's the issues from a very general perspective. In a competitive political, in a competitive polity in general, when you have political parties engaged in a sort of a competition to sort of get into power, federalism should have been, we had a great opportunity of reforming the federal structures when we had a long stint of coalition governments. We had where actually the state governments had huge say in the governance of the central government. And, we had a sort of a structural opportunity. And then we now have a central government where it's actually they seem to have a lot of power, and the structure itself is actually 1935 constitutional structure, which requires, I mean, rethinking. Obviously, this debate is very interesting. That we how do we sort of visit the federal frameworks. Now the basic issue is actually even chief ministers do what mayors have to do for cities, because most of the states, predominantly there are 2 or 3 cities which basically contribute to the whole economy. And what mayors should be doing, the chief minister is doing. And what the prime minister does is what chief ministers are doing. And so, in other words, even though there is a delineation of areas where you should actually do come up with schemes and this that. So there is always this overlap, because I think there is competition. And in a competitive polity, I think it is important that the mandate itself makes a huge difference in renegotiating these aspects, right? I was trying to understand if both Suhrit and Akila throw some light on this, because while idealistically we can say some things, but in a competitive polity, it has to be the people's mandate which sort of frames the policies. And we weren't able to do it in coalition governments. And how is it possible now?
So, Surit, I'd like you to respond to what Professor Vinay Kumar has said, while also adding a question to that based on what Professor Sumana Vedant said. She said there should be a policy, to ensure that politicians don't indulge in hate speech, but then policies are also framed by the government. So I'm just wondering, are there any constitutional safeguards for it? So yeah, this is a two-pronged
Sure.
question.
I mean, I think the difficulty here is not the absence of law or policy, but virtually the collapse of enforcement, right? At precisely the moments when it matters most. I mean, as Dr. Sumana said, India already has a fairly robust constitutional and statutory framework to deal with hate speech. You have Article 19(1)(a), which guarantees free speech, but you have restrictions on it, reasonable restrictions. One must be sure to mention that, in the interests of public order, decency, and morality, and so forth, which can be enforced through law. Now, of course, you have provisions in the erstwhile Indian Penal Code, which have now been further codified. And this is also supplemented by provisions in the Representation of the People Act, for example, which is particularly relevant in the context of politicians appealing to religion or indulging in hate speech and promoting enmity during the course of any electoral campaign, because the Representation of the People Act specifically delineates these as corrupt electoral practices. So the question is entirely one of enforcement and what when one does. And I think this sort of also comes to what Professor Vinay Kumar was mentioning, which is that, again, it's not the absence of a structure here. You have an independent judiciary, you have a constitution that delineates rights, you have various statutes which effectively criminalize hate speech. So, but the problem is when when the judiciary is dealing with matters such as this, there has to be a greater emphasis on ensuring that speech of this kind is clamped down immediately. You've had, I think, several instances recently, and we may not have the time to go over examples, but very many instances of matters of this kind reaching the highest court. And still we find that action hasn't quite been forthcoming for some reason or the other. And you've had television channels which have indulged in nothing short of open propaganda, and where promotions to the forthcoming broadcasts have clearly indicated that they have that they're possibly going to indulge in hate speech, but you've still not had a clampdown either at the level of the government or at the level of the courts. So ultimately, how do we ensure that? It has to come through movements similar to what Professor Vinay Kumar mentioned, which is that it has to come from the people. And we'll have to hold our elected leaders responsible. We'll have to hold people in other positions of power in the courts equally responsible, and try and see how we can, kind of achieve the constitutional morality that our constitution's framers hoped that we would.
Right. Thank you. So, Professor Vinay Kumar, your point is basically about single party hegemony, right? I mean, that can pose a threat to federalism.
So in a competitive political framework, actually, this is what happens. Congress was that party earlier. Now it is
Right.
BJP, as that party which actually has a huge mandate. But the fundamental thing is actually how the local governments, if they connect with their population, is very direct, and if it is strong, actually the local governments are supposed to be changing this, because no central schemes are going to be going to change this, and the connect between the state government with the state populace is the most important thing, I guess. And once you have that mandate, I think it is possible to negotiate, because you determine the Rajya Sabha members, right, in a certain way. So I think that architecture is there, but then these debates are very, very important, because the competition itself is going to create the narrative. And that's why you have a very aggressive political narrative uh, on both sides in a certain way, whether it is the right wing or the left wing, because you need to sort of garner the type of votes that you want, and that competition is the reason in a certain way. But my point is, the as long as state governments become very powerful, I think that's they'll be able to sort of renegotiate the state government and local parties in a specific way, because the national parties and local parties, the local parties have to have that strong mandate, I guess. I mean, that's what I see from an outsider in certain way.
Right. Akhila, so would you like to respond to this? Suhrit also said that the problem is of enforcement, and there are enough laws, there are enough constitutional safeguards. Who enforces this, though? Who enforces the enforcers is essentially what we should be worried about.
No, definitely. We have sufficient laws, whether it's civil, whether it's criminal, that try to control bad, insightful hate speech. But the problem is that the law on paper is very, very different from how it is enforced and how it is experienced by people. And I think this is emblematic of the larger problem that we are seeing, which is weakening of institutions, that autonomy of institutions seem compromised. So when we speak of the police or any other law enforcement agencies or independent institutions, because we've been speaking about the Election Commission as well, the problem is that they do not act in an impartial manner, but often act, in furtherance of dictates of their political masters, right? Which means that where harmful hate speech is made, which could possibly incite violence or perpetuate discrimination of marginalized communities, when it is made by persons who are close to power, it is left unchecked. And the problem is this inconsistent, almost arbitrary application and invocation of laws that exist. And like Suhirat mentioned, I think it's very important to go back to understanding the role of civil society organizations. There have been civil society organizations that are monitoring the instances of of hate speech and are seeking accountability, but to very little effect. But it definitely is a problem of institutions, and we need to try and ensure that there is strengthening of institutions and ensuring their autonomy.
Right. So basically, I think there's consensus here that civil society has a major role to play in stopping the growing of hate speeches. So on the one hand, we have politicians making hate speeches. On the other hand, you have, a student saying something or a comedian saying something, which, might not be palatable to most. It might not be the most elegant thing to say, but it's considered offensive, and if it's seen to offend someone's feelings, then there's a case registered against them, and so on. So, Akhila, let's start with you about this. So, who do you think, is there any statute that talks about what exactly offensive speech is, and is that a very broad category, and who decides what is offensive speech?
I think the simple answer should be that the courts decide what is offensive, what is criminal, what is not. But in reality, when it comes to prosecuting speech offenses, the process is the punishment, right? It's not just the courts ultimately deciding whether or not a speech that was made earlier was hateful, was insightful, harmful, but look at the entire machinery that's invoked. One, the police first gets involved in
Right.
registering the FIR. That's supposed to be a filter. But there is a problem there again because, as we already discussed, oftentimes registration of FIR or initiation of a criminal process is not on merits, on sort of substantive merits of a case, but in response to who is the perpetrator, response to who is the complainant, right? So it's invoked along those lines. What the person has to face is a long period of trial. Oftentimes, the High Court or the Supreme Court does not grant any remedy in the nature of quash of proceedings, etc. So you have to undergo a long period of trial. Ultimately, it may end up in an acquittal or a conviction, but the process here is the punishment, especially since, and we've noted this, oftentimes, a criminal complaint is registered in a very remote part of the country, which is unrelated to this person's place of domicile or residence. So, especially when it comes to creative expression, when it comes to political speech in the nature of protest, we see students, artists, persons who are activists engaging in political speech are targeted in this manner. And in a sense, then there is a heckler's veto. So who gets to decide what is offensive? It's not just about ultimate conviction or acquittal or compensation being granted. It is about, is free speech chilled in the interim period? Does the person have sufficient freedom to do what they want to do in the interim period? So the process is the punishment. So reality is that 19(1)(a) seems to be a rather restricted right, and not only in the sort of, in the reasonable restrictions way that's in 19(2).
Right. We have quite a few questions from the audience about this specific discussion that we're having on free speech. So maybe I'm just going to pose these questions to each one of you. Dr. Sumana Vedant, maybe we could start with you. There is Yashi Pandey who says the criminalization of hate speech has been a matter of chaos recently. What will be the consequences in case the hate speech is criminalized, and if it would directly violate our right to speech? I guess the question is the right to speech violated? Suhrit had mentioned that there are restrictions to hate speech, so maybe both Dr. Sumana Vedant and Suhrit could respond to this question.
Criminalizing hate speech, on one hand, if you see it, I mean, especially when it comes to the politicians, as you mentioned, in the campaigns and things like that, it may in a way it would restrict them, probably. So that should be a way out, according to me. So that probably will lessen down the intensity, I mean, to an extent. So otherwise, see, all these things, we as people, we need to understand things as to how we are united, how is that a diversified country like India, which stays united, and all these things are the ones which we need to inculcate in people. Rather, people should understand. So it cannot be something like you punish them and then make them realize and all these things. So probably it would lessen down. If you ask me, it may lessen down the
Suhrit?
Yeah, sure. I mean, look, I think often the contrast is drawn with America's First Amendment and how in India we have this sort of restrictions that are placed in Article 19.2. But if you look at free speech across the world, and it's not just a question of what speech is permissible, but also of balance of power across society. Most European democracies adopt, at least in theory, on paper, a principled standard that distinguishes hate speech from merely offensive speech. And as you quite rightly pointed out earlier, Radhika, it is sort of very distressing when the most vitriolic speech, which is aimed at different sects of society, are condoned. When you have, say, a passing remark by a stand-up comedian or something else which is clamped down on, and that is not how speech should be viewed in any democracy. Ultimately, we need to look at the values, I think, that our Constitution seeks to animate, the values of liberty, equality, and fraternity. Our problem has been with some of these colonial era laws, which we have supposedly sought to decolonize. For example, if you look at the earlier version of our penal code, the Indian Penal Code, you had two provisions, 153A and 295A, which criminalize respectively speech that seeks to promote enmity between different groups and speech that outrage religious feelings. And this has been carried into the Bharatiya Nyaya Sanhita, or the BNS, from 2023 onwards. But the problem with that is the kind of vagueness in these laws and the text of the law itself, in that they're often more prone to abuse and are not narrowly tailored enough to deal with those instances of hate speech which require, which necessarily have to be clamped down on. So I think one of the things that we need to kind of ensure is that speech must always reach a level of incitement to be criminalized, and the utterance must go beyond mere advocacy. And this will obviously require, I think, a reimagination of our hate speech laws, and it's something that we need to take seriously.
Right. Akhila, I'm going to pose the next question to you. So there's Akanksha who says, given the frequent failure of the model code of conduct, can constitutional morality be used by the courts to disqualify candidates under the Representation of the People's Act, or is that a step too far in judicial activism?
I don't think that the judiciary should step in and use constitutional morality to disqualify candidates. There can be, I think, and there should be meaningful debates about whether or not reform of electoral laws is necessary. And I understand the place where this concern comes from, where the Election Commission goes before the Supreme Court, where there are questions posed to it saying, are you toothless and completely powerless in the face of hate speech? So I understand the concern, and we see that the Election Commission perhaps needs more powers, but we need to understand that there are laws that speak to insightful, hateful speech. And the problem, like we've been discussing, is that application is rather arbitrary, and a lot of extremely hateful, insightful speech targeting minorities completely goes unchecked. So, and we need to be a little circumspect about any proposal to disqualify and exclude a person from the electoral process, because it can have rather far-reaching consequences on how our democracy itself is.
Of course, yes. And regarding the Supreme Court itself, I mean, the Supreme Court now recently said, hearing a writ petition, that all the hate speech matters that are pending before it since 2021 would be closed, and that these matters, the court said that the parties could, maybe pursue other remedies like moving the High Court or seeking police action. So, what happens in those cases? Anyway, sorry, that wasn't a question. That was just a comment since you brought up the Supreme Court. Let me go back to some of the questions that we have. We have many. Right. Dr. Sumana Vedant, Simant Kumar Nanda says, I have a question regarding constitutional safeguards and free speech. Recently, certain comments critical of the judiciary appeared in NCERT Class 8 textbook. Could the Supreme Court, under its constitutional jurisdiction, intervene in such cases? Also, sorry, there's another question. Also, in your view, how should the government, particularly bureaucrats in the HRD department, balance the need for educational content while avoiding inadvertent or intentional dissemination of remarks that may be perceived as adverse to the judiciary? Very good question.
When it comes to the content in educational say textbooks or whatever you say, probably it needs more curation, and authenticity should be probably the biggest thing that should be ensured. So in order to do that, I don't know how Supreme Court can really step in and make them do something. But then it is probably very difficult to do that, according to me. So it is, yes, it is, so it becomes necessary, but then, more of curation is what is required, if you ask me, when it comes to, the textbooks from various sources.
Sorry, ma'am. So by more of curation, so could you expand on that? I didn't quite understand.
In the sense, see now, whenever you want children to learn something, so there is an objective behind it, correct? There's an objective behind it. You want children to know something for a reason, right? And what they should know, and whether that whatever they are publishing or whatever they are putting it in the textbook is authentic, that needs to be ensured. So the authenticity is a problem. So if if it is just gathering some sources from somewhere and then putting up in the textbook, see now there's another issue there, because now it is just not one syllabus or whatever, one kind of textbook that you have. You have so many models. You have NCERT, you have ICSE, you have so many things. So everybody is catering to different group of different experts. So this is what is the issue. So if you can make, okay, then I would say that you make one kind of whatever syllabus or whatever you want children to study, make it equal, like make it totally uniform across. Then that would probably solve your problem. But because you are catering to so many different varieties of syllabus and things like that, the authenticity is the only problem.
Suhrit, would you say that authenticity is the problem, and do you think that what can the government do to balance the need for educational contact while also sort of being careful of how the judiciary perceives remarks that of itself?
Look, in this is really a sort of a question of the kind of processes that a government must have in terms of how how textbooks are written. And obviously it has certain processes in play. I wouldn't want to say too much on the ongoing matter itself, given that the court is still hearing it. But I think let's leave aside this particular chapter for a moment. I think there are obviously larger concerns in terms of how these textbooks are written, in not just on the law or on the judiciary, but on other areas as well, history and sociology and whatnot. And so obviously, again, there has to be, any government would have to ensure that it maintains a fidelity to the kind of values that our constitution requires of our leaders, in order to ensure that textbooks are written in a manner which will educate our children, and which will at the same time give them the kind of a flavor for debate, to think about, and not just sort of preach something from the top to them, in order to ensure that we build thinkers for the future, really.
Right. I'm going to pose the next question to you as well. I think this is about the centralizing bias of the Constitution, which of course, is something that is a fact given how it came into place because of nationalism. And the factors that played a role back then. But the question really is the tussle between the center and states. It escalates when there's a conflict of interpretation of powers provided in the concurrent list. And the issue currently is that the center, having an upper hand, which is the centralizing bias, can easily dominate such conflicts. So what could be done to solve or at least diminish this confusion? And how do we reduce overriding powers of both the center and the state for matters in the concurrent list with respect to interpretational challenges?
Yeah, I think, look, there's obviously a so-called centralizing drift of the Constitution that's often spoken about. And I think where things need to change is that in interpreting the Constitution itself, because the power is so heavily tilted in favor of the Union, where there is a conflict, and this is sort of slightly counterintuitive, where there is a conflict, I think the courts need to ensure that the state's autonomy is preserved and that that sort of benefit of doubt is given to the autonomy of the states rather than interpret the Constitution once again with a kind of centralizing tilt. Because obviously we are, as the person asking the question rightly points out, in a matter on the concurrent list, once the union government brings a law to override a state law, then there's really very little that the state can do, except it can bring another law, but it'll require the assent of the president in order for the law to prevail, which then makes it very difficult. In many cases, there are obviously exceptions to this. But I think where there is a conflict of power between the union and the state, and there are very many conflicts that arise, you've had, and you've had some pretty, I think, good judgments on this on occasion. For example, with respect to mining leases and royalty payable on mines. If you look at the 9-judge bench judgment in the mining matter, the court did employ, I think, some of these interpretational tools to in fact ensure that the Constitution doesn't get further tilted towards the center when a kind of conflict arises between these powers. So therefore, the solution really lies, I think, in interpretive techniques and ensuring that the text isn't interpreted in a manner that will further centralize the drift.
Akhila, there's a question about sedition. Now, this is not something that we have discussed, but it would be interesting to touch upon it since, it does come up every now and then. Somebody says in a federal republic, Gopinath K says, in a federal republic where sovereignty rests with the people through their elected representatives, does the aggressive use of sedition laws by states to silence dissent, does it protect the republic or does it betray its democratic soul?
I think that's a very important question. And yes, with regard to sedition itself, if we can recall, under the IPC, when the constitutionality was being heard by the Supreme Court, there were representations made that, of course, sedition is going to be repealed. We are not going to have it anymore. And we know the history of sedition law itself, right, where it was put in place in order to control political activism, independence, and our freedom fighters, founders of the nation, were directly affected by it. But later on, I think it was found convenient for the governments in power and continued altogether. I think, and Kedarnath's judgment definitely limits and places sedition and the provision, locates it within the sort of folds of 19(1)(a) and 19(2). But the problem is, again, the manner in which it is invoked, that any critical speech can potentially be targeted, can be prosecuted. I agree that sedition is, abused. Again, the BNS brings it back in a slightly different form. And we definitely should not prosecute or criminalize speech that speaks against the government or against the state, and only, act upon anything that touches upon violence and directly incites violence, right? Otherwise, we run the risk of entirely obliterating any, critical speech, which is antithetical to democracy. You can't have, fruitful democracy at all.
I think your answer also works as an answer for another question here about how a lot of people say things on social media which are very offensive and should all of it be criminalized, which could be problematic, as she just said, because then, that gives the state immense powers. Suhrit, there's a question that's specifically addressed to you. It says you mentioned, this is from Deepika Nath. She says you mentioned the need to protect constitutional morality. Yet yesterday, Mr. Kapil Sibal argued that morality is not a static concept and changes over time. Given this and your position that there is no need to amend the constitution, don't you think it is necessary to rethink the concept of constitutional morality itself?
No, I don't think there's a need to rethink this concept. I mean, look, ultimately, our constitution gives us certain values, and you look at the preamble, you look at the fundamental rights, you look at the directive principles, and you try and arrive at the larger vision that the constitution seeks to espouse. And that's really what we mean by constitutional morality. Morality from a public standpoint might change from time to time, which is why when you look at the judgment of the Supreme Court in Naz Foundation, where it struck down Section 377 of the Indian Penal Code, or when you look at the original Sabarimala judgment, etc., these principles of constitutional morality were invoked to ensure that that vision that the Constitution's founders gave us were respected. So it's really it's not that you can strike down a law or something on the ground of it violating constitutional morality. It's more, again, an interpretive tool. When you try and interpret certain provisions of the Constitution or interpret certain provisions of statutory text, you try and keep these larger ideals in mind. So I don't think there's a need to rethink that, really.
Right. The next question I'm going to pose to all of you, I mean, whoever feels comfortable, please take it up, because it's a bit of a historical question. It says, this is Apur Srivastava says, as far as India is concerned, it has never been a true federation, but still the constitution makers wanted federal features in the constitution. What was the rationale behind such a step? Would anybody like to respond to this?
I mean, why,
Sure.
why do you think that it was not a federation?
Yeah, I mean, if I can respond, look, even under the Government of India Act 1935, there were divisions between the various lists. I mean, there was a union list and there was a provincial list, even prior to the Constitution. So the idea was for India to always be a union of states, in that states would enjoy autonomy over there. And look, I think when we speak of federalism, we should also speak of something else, not just the union and the states, but also the level of local government. And I think that's something that we might not have spent much time on today. After the 73rd and 74th Amendment, there's been a further decentralization of power. And when the states often speak about the centralizing drift of the Constitution, or the fact that state interests or state powers are often limited, I think states have a responsibility equally to ensure that local governance is respected. So therefore, I think it's important that we keep that in mind as well, really.
Dr. Vedant, did you want to say something?
No, I mean, I totally agree with him. So, I mean, see, even if we are looking at history also, as he rightly pointed out, it was already there. So, where does this doubt lie as to we are not a federation or something like that? I mean, where does it come from? So that's my point.
Right. It's a question from one of the students. So we had discussed whether the governor's assembly address is necessary. Someone has a question on whether the post of governor itself is necessary, given the deteriorating relations between, the right now the BJP-led central government and many of the opposition parties-led governments in many states. So does anybody want to respond to whether we should be rethinking the post of governor itself? Akila, do you want to address this?
Sure. And I think this also, continues from the last question, right? When it comes to these structural choices or having, offices and certain institutions in the Constitution, was a matter of historically was also due to some amount of continuity that was necessary in order to have like a smooth transition as an independent republic. So with the position of governor, as well as some kind of federal and unitary distinct choices. Now, is it necessary? We definitely are seeing a lot of friction, not just in this decade, but it's been something that most states have seen over the past several decades, which definitely requires us to look into what is the function of the governor. Do they have discretionary powers, or is it largely ceremonial? And I think most people would agree that it is, even though they are the titular head of the state, most of their functions are ceremonial in nature. Of course, there are some executive functions that they do have, right? When it comes to imposition of president's rule, calling upon to form a government, etc. So there are important functions that are specified and that the governor still enjoys. But it's definitely important to reform either through interpretation or build consensus to ensure that there is proper cooperative federalism, and that the positioning of the governor is not one that disrupts democracy and takes away from a democratically elected government, rather to build a bridge between the union and the states.
So I think we're running out of time, but I'm going to take one last question. And, because we had spoken about the importance of civil society, I think this question sort of ties up with that. Um, Itasha Roy says, on free speech and social media, young Indians are politically vocal online but disengaged offline. Is digital activism strengthening democracy or replacing real accountability? Because the youth, she says, are not aware of what they can or cannot say. And even something is permitted but controversial to a certain group, there are real life consequences, such as filing of charges, content shutdown, so on. So, yes, is digital activism strengthening democracy or replacing real accountability? Akila, you can go. I
Yeah.
feel like you have something to say.
uh, because it had my name. So it this is
Oh,
not
it
a
does.
zero
Okay.
sum. Yeah, this is not a
Yeah.
zero sum game. So I don't think digital activism takes away from, detracts from offline advocacy and grassroots movements. We need to accept the fact that the way people engage or come together has changed, right? So in as much as digital spaces offer an alternative, it needs to be made use of, cannot be ignored, cannot be, I think, given undue priority and then say that offline engagement is unnecessary, because that also happens, right? Like, especially when it comes to, say, permissions to hold physical meetings, oftentimes the government even shuts it down, police shuts it down, saying, well, you do have an online option, so why do you need this? So I don't think it's a zero sum game. It is not a substitute. It is yet another mode of engagement. And if youngsters are more comfortable starting with engagement online, I think it's a welcome thing to do. But again, my problem is where you consider online freedom as sufficient and deny a person to engage in physical spaces as well, because the physical space for democracy and dissent is deeply shrinking. That goes beyond what we are talking about today, but we need to understand that in context. But I think we also need to validate the fears and anxiety of young people. Well, are they engaging in online advocacy because of fear that there could be physical action, criminal action that they are facing? These days, it's even social media is a dangerous place, right? As in, we see young persons who want to do activism, who want to have political, engagement, are being targeted. So it is dangerous, but it is heartening to see that that is not stopping everybody. You still want to be engaged, and we need to encourage it at every point.
You spoke about the shrinking of physical spaces for such activism. Do you think the increase of online activism is a consequence of that?
No, I'm not sure. I don't know if there would be a direct causation,
Sure.
right? But it at least provides some safe space.
Some space.
Yeah, but
Yes.
is it entirely safe? Not really, because there is a
Yes.
lot of policing in that sphere as well.
Right. All right. Okay. Thank you. And I'm really sorry to all the um, to all the audience members who have more questions, we simply don't have the time to address them. Maybe we could take them offline. Thank you to the speakers for joining us on a Sunday morning and having this wonderful discussion on some of the most pressing issues of today. Of course, these discussions are ongoing and they will continue to be. And thank you to SRM University. And I hope you all have a wonderful Sunday. I think it is time to sign off.
Thank you.
Hello.